last module, we discussed the conceptual framework of intellectual property rights and its forms. Intellectual property has a dual character. It is registered nationally but has international implication. Let me give you an example. Say an inventor patents his invention under the Indian patent law. There are international conventions that ensure minimum rights to the inventor and provides for enforcement of these rights by the contracting states. So it becomes essential to understand the national as well as international dimensions of IP. Through this video, let's begin with the oldest international convention, which is the Paris Convention of 1883. The Paris Convention for the Protection of the Industrial Property was signed in Paris on 20th March 1883, making it one of the first IP treaties. The substantive provisions of the convention fall into three main categories: national treatment, priority rights, and common rules. And the convention is enforced even today. As you see, the nomenclature industrial property seems to apply to all industrial property in its widest sense. It includes patents, trademarks, copyrights, industrial designs, utility models, etc. It is indeed a major step to help inventors and creators protect their works in other countries and thereby establish markets. The convention is administered by the World Intellectual Property Rights Organization or WIPO. And now let's look at the three substantive provisions of the convention. The first one is the national treatment. The convention provides that the contracting state must grant the same protection of IP to the nationals of other contracting states that it grants to its own nationals. So if I, as an inventor, wish to apply for a patent, I would have to apply in my home country, that is India. Suppose I have a franchisee or an establishment in a contracting state, say France, and if I am granted a patent for the same invention, then I would be entitled to the same national treatment under the convention as would be granted to its citizens. However, the important requirement is that the IP holder must be a domicile or have a real and effective industrial or commercial establishment in the contracting state. Then the convention provides for right of priority. This is in the case of patents, trademarks, and designs. This means based on the regular first application filed in the contracting state, the inventor can apply for the protection in any other contracting state within a predetermined period of time. Let's take an example. Suppose I, as an inventor, apply for a patent in my home country on 1st January 2022. I would have 12 months' time to apply for the same patent in another contracting state. The advantage is that these subsequent applications would be regarded as if they had been filed on the same day as the first application. In other words, they would have priority over the application filed by others during the same period of time for the same invention. And that is why it is called the right of priority. So applicants who wish to apply for foreign filing of patents would have 6 to 12 months to decide in which country they wish to seek protection and organize themselves accordingly. And coming to the common rules, some of them worth noting are patents granted in different contracting states for the same inventions are independent of each other. Likewise with trademarks, that is registration of a patent or a mark obtained in one contracting state is independent of its possible registration in another country. The inventor has the right to be named as such in the patent. Each contracting state must take legislative measures to provide for grant of compulsory license to prevent abuse of patents. Abuse here could relate to failure to work the patent or insufficient working of the patented invention. With regard to industrial designs, the convention states that the design must be protected in each contracting state. It need not be forfeited simply on the grounds that the articles incorporating the design are not manufactured in that state. With regard to protection of trade names, each contracting state must protect the trade names without there being an obligation to file or register the name. The convention also lays provisions regarding geographical indication. The contracting state must take measures against false indications of source of goods or identity of their producer, whether directly or indirect. Each contracting state provides for effective protections against unfair competition. This brings us to the end of this video.